In this, our first week, we're going to look at ethics and three types of law. I'm going to start with the three types of law because, as you will see, ethics fits within one or more of these types of law. The first type of law that a school administrator must be aware of is called administrative law. Administrative law is everywhere in a school principal's life. Let's start with administrative law in the form of school board policy. Every policy that the school board passes is a form of administrative law. If your school board has adopted a collective bargaining agreement, if it has adopted a manual for student rights and responsibilities, that's administrative law. You have to follow it. You have to, as we say, ride the brand of your school district. You're following administrative law when you deal with board policies and with other kinds of manuals or agreements adopted by the school board. Now, another kind of administrative law is the pattern of practice that has been established by the school administrators. Sometimes there will not be a written policy, but over time, this pattern of practice becomes the same as policy. And in some states, highly unionized states, such as Oregon and Washington, the practice is where the grieving party will go to first, because in the practice, it's easy to find inconsistency. Whereas if there is a written policy, it's less likely the school administrators from school to school will be acting differently. They're going to follow the policy. That's why some board policy manuals get so thick. They want to make sure that there's consistency in each of the schools because they know a pattern of practice is kind of low-hanging fruit for a grieving party. Another form of administrative law is at state agencies. For the Idaho educator, the most important state agency is the State Board of Education. Each time the State Board meets and adopts a new board rule, that becomes a new form of administrative law that we have to follow. It might be a new rule on student testing. It might be a new rule on curriculum. It might be a new rule on standards for you as a school administrator to get certified. That's administrative law. And you can see how important it becomes in terms of ethics, because the state board, when they adopt these standards for certification, are playing right on the center field of ethical requirements, because the next item that they can move into is the Code of Ethics. The Idaho Educator Code of Ethics is adopted by the State Board of Education. That becomes the administrative law where, again, a grieving party is going to go to if they think you've made a mistake. They're going to see, has he violated some element of the Code of Ethics, some element of the standard for certification. So when these agencies meet and have a hearing to make a determination, when the Professional Standards Commission meets to hear a complaint about a teacher or an administrator, that's an administrative hearing based on administrative law. When the local school board meets to consider a teacher's discipline, that's administrative law in action. They're going to make a ruling that is an administrative decision. So administrative law works at the school district level, and it also works at the state agency level. Now, the next level of law is something called legislative law. Legislative law is when the Idaho State Legislature passes a new bill and makes a new statute. Legislative law is sometimes called the law of Idaho, the law of Washington, the law of Alaska. Sometimes it's called the Code of Oregon, the Code of Washington, or the Idaho Code. But legislative law is a step above administrative law because it is statutory and it applies to all state agencies, whereas an administrative law passed by a school district works only in that school district. But when the state legislature passes a law, it becomes legislative law, and it applies to all school districts. Another kind of legislative law is, of course, congressional actions that may take place, and a new federal law comes into play. A new federal law on special education, perhaps. A new federal law on integration. A new federal law on, let's say, some aspect of gun safety. All of this represents the second level of law, known as legislative law. That legislative law applies to all similarly placed state agencies, all state agencies that may be affected by a federal statute. Now, the third type of law is case law. Case law is judge-made law, court-made law. I know that you're going to be thinking, well, courts don't make law. Well, as a matter of fact, they do, because courts will interpret a statute, and their interpretation of that statute becomes law. That's the law of the land. We have to follow what the court says that they found the statute to mean. And that's only going to change when the legislative body, Congress, or perhaps at a state level, the state legislature, changes that law, and they're, in a way, providing a check and balance against the third branch of government, the courts. They're saying, well, your ruling last year on desegregation no longer applies because we've changed the law. We've adopted a new law. Now the courts will have to wait for a complaint to be heard and perhaps a new ruling made that, again, interprets that particular law. So there are three types of law. We're going to look at all of them: administrative law, legislative law, and judge-made or case law. Very important for the school administrator, because each of these will help you make a good decision. How do you keep track of all of them? Well, I suggested you think about this mnemonic that I call PRICE, P-R-I-C-E. Each time you make a legal decision, you pay a price. And I urge you to take time to think about price you're going to pay. Starting with P, what's the policy of the district? If there's no policy, is there a past practice, a pattern of practice? The R being regulatory language. Is there a handbook? Is there some kind of regulation at the state agency level, administrative law, administrative regulation level? And then the IC, combining those two letters, they're going to have a dual meaning here. IC for you as the Idaho educator means Idaho Code. For you as the Oregonian, IC will mean informing code. What is the informing code? State statute, legislative law that I need to be aware of. And then we're going to make ICUs to represent as well informing cases. Is there an informing case at the state level, at the Ninth Circuit level, at the U.S. Supreme Court level that I need to remember? Oh yeah, that's right, I forgot that in Barnett, the United States Supreme Court ruled in Barnett, students do not have to behave patriotically. We can't require them to do that. They can take a knee, and the Idaho law has followed that Supreme Court ruling. So I now have applied both the IC in terms of informing case law, the IC being the Idaho Code on patriotic instruction. And finally, there's the letter E, E representing evidence. Do I have all of the evidence I need before I make a good legal decision? Gathering evidence is an important due process step. And we're going to look at price. We're going to look at the three types of laws. We're going to look at due process in this course. In the first week, we're looking at ethics as a form of administrative law, and you will see as a form of legislative law. We might even see ethics pop up in some case law, where a court will say the plaintiff is correct, the defending school administrator violated the Idaho Educator Code of Ethics, and we find for the plaintiff. So you can see how these three levels of law interact with each other and how ethics as a foundation for school administrator performance is going to be present in all of them.